Hello there, and welcome to the Employment Law Show. Just in case you've never caught us before, you've been trapped under something heavy. John Scholes, Lior Samfiru. I simply talk. He has all the knowledge, which is, as long as one of us are informing you of the good things of employment law, that's really all you need to know. You want to reach out anytime, 1-855-821-5900. That is the number. There is always pocketemploymentlawyer.ca. Now, when you created this a few months ago at the end of last year, it was hot off the heels of the severance pay calculator, which, by the way, has been rolled into pocketemploymentlawyer.ca. And severance pay calculator had 750,000 hits on it, and this particular website is so much more robust. I can see in a year or 2 years from now, the entire country is going to have a look at this thing for sure. So we're hoping for that. Anyway, help@employmentlawyer.ca is the email address, and if you shorten that to employmentlawyer.ca, that is the website. From there, you can catch past TV shows and our long-running radio show as well. We'll get to some calls from the radio show here in just a bit, and we're going to talk about what you need to know about fixed-term contracts in just a little while. But first, pal, always the week that was. What's going on?
It's been an interesting week, busy week. Spoke with a lot of people that watched this show, and then it triggered something, a question, an issue, a problem that they wanted resolved or addressed. So that's wonderful. That's why we're here. We're not going to be able in our 30 minutes to cover every aspect of employment law on every show. So you may have issues about your workplace situation that is different, that's unique. Call me, email me. We'll give you my contact information throughout the show. I'm very easy to reach. There's no bad questions. We'll try to answer as many questions on the show, but I'll talk to you, or someone on my team will get that problem resolved. There's always answers to workplace issues, and it's because the law is quite robust. The law is quite strong in this province in protecting employees and ensuring that employees have access to justice and information. So if you don't know what you're owed, if you don't know what your rights are, it starts by making a quick call or reaching out to me, and I'll tell you. But to get us started, let me talk about a week that was, situations that came across my desk just very recently. I spoke with a lady who had been off on a disability for about 18 months. She had a serious medical condition, but throughout this time, she was working really hard and getting healthier, getting better, so she can get back to work. She saw that as almost as a personal challenge for her to get healthy enough to get back to work. And good news, after 18 months, she got the green light from her doctor to go back to work. Very happy, very excited about that. The doctor did say that we need you for a while to go back on a part-time basis, on a gradual return to work basis.
Ease into it. Yeah.
So that, you ease into it and slowly build your way back up over a few months, back to full-time. Very common. So very excited. She calls the company, says, good news, I can come back to work. I can start on a part-time basis on Monday, and over time build my way back up to doing exactly what I did before. Well, right on that call, the company says, well, no, we can't do that. We can't allow you to go back part-time. Everyone here is working full-time. We can't make exceptions. So we can only give you full-time employment. So we're not going to bring you back. When you're ready to come back to work, give us a note from your doctor, and then we'll take you back full-time. Not congratulations, not so happy that you're better. So obviously upset, she called me, and she wanted to know, what are my rights here? So John, this is not complicated from a legal standpoint. An employer has a very strict duty to accommodate. That means providing that modified hours, modified duties, what have you, to allow her to work despite her physical limitations. So in this particular situation, she needed part-time work. The company has to make all efforts to provide that. They can't say, well, we don't really want to, no one else gets it, it's kind of hard to do. They can't do that. The company has to do that even if it is hard. So this failure to accommodate is a human rights violation. It's illegal. They should have allowed her back to work. This is something that happens often with people that have a medical condition. You may need modified hours, modified duties, flexibility to work from home, assistance in getting your job done. With all these situations, the company has to make all efforts to make it happen. It's our human rights laws here. So in this situation, what does that mean? It's a human rights violation right off the bat, so which means you may be owed compensation for that. But also, this failure to bring her back to work when she can come back, when they have to bring her back, in itself is actually a termination. She has a right to treat this as a termination and pursue her severance as well as human rights damages, and that's exactly what she's going to do, and I'm going to help her do it. So I wanted to remind our viewers at home, if you have a medical condition, remember, the company has to accommodate you. It's a strict duty. It's one of the most basic, most fundamental duties when it comes to workplace law in this province. If the company doesn't want to, they don't try hard enough, they don't think it's their obligation, That's wrong. That's illegal. You got to reach out to me.
Especially the larger the company, the more HR they have, the easier it will be to find you a place, really.
If you're working for a major corporation, there's a lot of resources they have, a lot of jobs, a lot of places they could use you in part of the accommodation. So it's going to be very difficult for a large company to say, oh gosh, that's too much, that's too hard. Whereas if you work for a small mom and pop organization with 1 or 2 employees, they may not have the ability to accommodate you. They still have to try and they have to still make all efforts, but it may be more difficult. But in this case specifically, she was working for a pretty large company.
Yeah,
they had to accommodate. They didn't even want to try, and that's illegal.
Employmentlawyer.ca, the website where you can find past shows of this nature or the radio show as well, which has been going on for years and years. Some good stuff there as well. We take phone calls each week. We'd like to play them back here on the TV show and dissect and get some information. So we'll get to call number 1 for today right now.
I'm a real estate agent. I've been with this brokerage for almost 5 years. I was considered more of an independent contractor due to an extremely stressful work environment and some personal issues going on in my family. I took a leave of absence, but they terminated me basically a month before I was expected to go back. They offered me a 3-week severance pay, and they are giving me a week and a half to sign. I've earned basically about $125,000 of future commissions that I haven't been paid out yet. Kind of a little stuck on what to do, to be honest with you.
I've asked you so many times over the years about real estate agents. It seems like a weird area as far as contractor employee because of what they do. They work from home, but they're using the company. I don't know. How does it fit in?
There's a lot to unpack here.
Yeah.
But generally speaking, in terms of what the law would determine you to be, if you work with one brokerage house, you're dependent on them, on their leads, and you work just with them, you are going to be considered to be an employee.
Cool.
So you may be a real estate agent at home right now, and almost all of you would believe that you are really independent contractors. And I'm not going to tell you that you need to pursue it or not, but the law is very, very likely to consider you to be employees, not independent contractor. You've been misclassified. Same with this person. For 5 years, there's no way he's working exclusively for them for 5 years, and he is not an employee. So he's an employee. Now, beyond that, he goes off on a medical leave, okay? And instead of bringing him back, he's being terminated. Well, unless there's a good reason why he's terminated, maybe they shut down the location and they had to let everyone go, fine. If he's the only one, it certainly makes it look like he was let go because he was off on a disability leave, and that's illegal. You cannot be let go because you're sick, because you took a disability leave. That's a human rights violation. We've talked about human rights violations before. You cannot be punished, mistreated, let go because you have a disability, because you took a disability leave. So it appears that's what happened here. So number 1, we have a misclassification. Number 2, we have potentially a human rights violation. Number 3, we also have a wrongful dismissal because after 5 years, he was given a week to accept 3 weeks' pay. So he's out. He's probably owed closer to 6 months' pay, maybe more than that. So it's a wrongful dismissal. It's a human rights violation. It's a misclassification. It's all those things rolled into one. So remember, there's important lessons there. You cannot be let go if you come back from a medical leave because you took a medical leave. You're probably misclassified if you work for 4 or 5 years in this case. And guess what? If you're let go, chances are over 90% chance that you're owed a lot more than what the company's offered.
And he also said he still owed $125K in commissions. That's a lot of coin.
That's a lot of coin. So there's a lot of here. So I'm going to connect with this person. We're going to help him get what he's owed. This company, this employer has done pretty much everything wrong.
Again, a great resource for you anytime is pocketemploymentlawyer.ca. Not only tells you about being an independent contractor or a full-time employee or constructive dismissal, there's even a section there on disability law as well for your partner, Tumarkin, on the Disability Law Show. Snuck that in there, but it's really robust. And again, it has a lot to do. There's a lot of interplay, as Savannah likes to say, between employment law and disability law. But tell me a little more about the Pocket Employment Lawyer.
John, you said it perfectly. We wanted to give everyone access to that information, to legal information, all the time, 24/7. We wanted to give everyone their own individual employment lawyer. And so we did that. You have an employment lawyer with you. Free, anonymous, easy to use. It's right on your phone. Go to pocketemploymentlawyer.ca. Find out how much severance you're owed. The first place you go to, by the way, if you have lost your job, if you're staring at those severance papers, want to make some sense out of those, you just go to pocketemploymentlawyer.ca, answer about 3 questions, find out how much you're owed. But if you want to know if you've been misclassified, like in the example we've talked about, if you want to know if you're being let go for cause properly, if there's a constructive dismissal, if it's a human rights violation and more, you can find all those things out All those on pocketemploymentlawyer.ca. You already have an employment lawyer. Now you just have to check it out, pocketemploymentlawyer.ca.
Always good to toss an example out there, and we'll do exactly that. Edwin writes in, says, a coworker quit last week. Instead of replacing him, the company shifted half his workload to me. Not always a big surprise. He says, I'm not really qualified to do his type of work, and the quality of my original work is now being affected because of that. How do I address this issue with my employer of 3 years?
I've seen this often, John, a situation where the company is not necessarily changing your job title. They're not officially changing your role. They're just giving you a bunch more responsibilities, a bunch more tasks, things that were not originally part of your job. Maybe it's because they're restructuring. Maybe they're trying to save money. Instead of hiring another person, they'll just double the workload on you. Well, guess what that does? That changes the terms of employment. If you had a particular job that you've agreed to do, that's your job. Now that job is different. Now, instead of having 5 tasks, you have 10. Now, instead of having to do 20 things in a week, you have to do 25 things or 35 things in a week. Well, then that is a change. And when we talk about these changes, we always think about constructive dismissal. If an employer changes the terms of employment, it may give rise to a constructive dismissal. So in this situation you just read, let's take that fact scenario and let's plug it into pocketemploymentlawyer.ca so the people watching us at home can see how it works. You can do the same thing with your situation. So when we go to pocketemploymentlawyer.ca, we'll see a feature there talking about changes to the terms of employment. Right. We'll pick that there, and we'll answer a few questions. So this person's been there for 3 years. The type of change was change to his duties and workload. Has the employer done this before? No. And then we can see in the bottom the answer, in terms of is this a constructive dismissal? And the answer is, since your duties and workloads have significantly changed, and this hasn't happened before, this is likely a constructive dismissal. So right there you find out that, yes, your scenario is a constructive dismissal, which it is. If that's happened to you, if your employer give you additional duties, they change the job, even if the pay is the same, that may still be something the company is not allowed to do, something that gives you the right to treat it as a constructive dismissal. Call me or email, or certainly go to pocketemploymentlawyer.ca.
Now, you mentioned, have they done it before? No. Now, if they maybe this is the first time, but maybe this employer, as you like to say, wants to be the good soldier and decides to suck it up for 4, 5, 6, 7 months and then goes, you know what? I don't want to do this now. Does he have any recourse? That's
a problem. Yeah. Once you're the good soldier, and that's the term that I like to use. You want to be a team player. You want to be the good soldier. You want to, okay, I'm not happy, but I'm going to make this work. The problem with doing that, the problem with accepting a change to the terms of employment is you've given the company the right to do it again. So if in this particular situation, the company had changed his terms of employment before, they changed his responsibilities or workload, he now may be able, or the company may be able to do it again without him having any recourse. That's why it's so important to stand up for your rights. If the job changes, if your pay changes, if you're being demoted, if you're being relocated, what have you, it's good to say, no, I'm not accepting that. And if I have to, I'm going to treat that as a constructive dismissal. Because sometimes the good soldier may find themselves in a situation where now the job that they agreed to is not the job that they have, and nothing they can do about it.
All right, coming up here, what you need to know about fixed-term contracts. We'll get to that after our break. 1-855-821-5900 and online to employmentlawyer.ca. That's all coming up in the Employment Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And And welcome back to the Employment Law Show. To reach out, 1-855-821-5900. I'd just like to remind you, I know they throw it up there on the screen. help@employmentlawyer.ca is the email address. And as we discussed reasonably in depth in our first part of the show, pocketemploymentlawyer.ca, all kinds of information there for you to peruse. It's like, as Lior says, having a pocket employment lawyer with you at all times, so you want to check that out. All right, what you need to know about fixed-term contracts. Let's get right into this. What are they, first of all?
So a fixed-term contract, when it comes to employment, we're talking specifically employment, is an employment arrangement for a specific period of time, a defined period of time. That period of time could be anything. It could be a month, it could be 6 years, it could be anything in between. So most people, when they accept a job, it's an indefinite job. You're going to work here until you leave or we let you go. We call that an indefinite employment arrangement. A fixed-term contract or a fixed-term arrangement is an agreement where from the beginning, we know that we hired you for a year, for 2 years, for 3 years. So that's what that is. And that can happen often when a company maybe has an employee that's gone for a period of time and they need to cover for that, or maybe they hire someone for a specific project. And we want to talk about the rights of those employees that are in a fixed-term contract, because certainly when it comes to the termination of that type of an arrangement, there could be significant entitlements.
Well, you did mention that. I remember years ago we had that conversation on the radio show, and there was a guy, you said 6 months into like a 3-year contract, they let him go. Can they do that, and are they owed anything? The employee I'm talking about.
That's right. So obviously, you can be let go if you're on a fixed-term contract. You can be let go on day one or on any other day. Well, the thing is this, though. If you are on a fixed-term contract, on a contract for a specific period of time, and you're let go before the contract ends, the general rule is that the company still has to pay you out the balance of that contract. So that specific situation actually was a 5-year contract. The person was let go after 6 months, and the company said, we're going to be nice, we're going to give you a week's pay. Contacted me and I said, you realize you're owed another 4.5 years pay. 4.5 years pay because you signed a 5-year contract. They let you go after 6 months. They have to pay you the difference. And guess what happened as soon as I approached the company? Come back to work.
No kidding.
And he was happy to do that.
Yeah.
So the general rule, this is important for you to understand. If you signed a 1-year contract and 4 months, as an example, into it, you were let go, the company has to pay you, not the usual severance. We don't look at the usual factors. They simply have to pay you the difference, the balance. And for many people, that can mean a lot of compensation. Unless there's cause, unless you did something awful, the company's going to have to pay you the balance. And if they don't, that's a breach of contract, that's a wrongful dismissal. It's illegal.
Talking about fixed-term contracts here, what if it goes the other way and, the person's on a 2, 3, 5-year fixed term, keeps working, everything's peachy, and, 5 years kind of comes and goes and everybody forgets about it and he's still working there?
That happens often. Let's say you have a 5-year, 2-year, 1-year contract. The contract ends and you continue working. No one really pays attention to it. And you're still there. Well, what does that mean? Well, as soon as that contract expires and you continued working, now you're a regular indefinite employee, which means you're now an employee without a fixed-term contract because the contract has expired. You're a regular employee, which means if at some point the company says, now we want to let you go, they have to pay you severance as a regular indefinite employee. So for many people, that may be a good thing. Frankly, if your contract ends on October 29th, and the next day, November 1st, you're still there, just by the very next day still being there, you're now a regular employee. So if they want to let you go November 2nd in that example, no, they have to pay you full severance because now the contract is expired, you continued working, you have the rights of an indefinite employee.
But do they have to pay you in the 2 days since it expired, or for the duration previous when the contract was still enabled?
They have to pay him severance based on the whole time he was there,
no kidding.
Not just the 2 days, it could be 1 year, 2 years, 5 years. The whole period of time you're with the company, even when you're on a contract, counts towards your termination entitlements.
If it ends and the employer signs you to another contract and that ends and they sign you to another contract and so on and so forth, how long can this go on?
So here's kind of a scenario, and I've seen this happen many times. So let's say it's a 1-year contract. Contract expires, you sign a new one, another contract expires, a new one, and off and on. And eventually the company says, now we're done. Now we're not going to renew the contract. So long, farewell. So the question there becomes, because the company simply waited until the end of the contract, should they have to pay you any severance? And the answer is yes, absolutely. When you signed a number of contracts, after a number of contracts, the law says, well, you know what? Enough is enough. Clearly, he's no longer on a contract. If he signed a bunch of contracts, he expects to continue working. So you have to treat him. You have to pay him severance like a regular employee. Usually after about 2 or 3 contracts, probably about 3 contracts, once you've signed 3 contracts, those contracts become irrelevant. They're meaningless. So even if you sign 5, 6, 10, who cares? The law is going to consider you to be an indefinite employee, which means if the company decides, now you're gone, now we're not signing another one, fair enough, they could do that. But they would have to pay you full severance to account for the whole time you were there, all the year you were with the company. So signing a bunch of contracts doesn't help a company. May as well just hire someone as an indefinite regular employee, because the law is going to get there anyway.
Does it make a difference for the employer if every time you sign a contract there's reasonably significant changes in the contract, or not really?
If you negotiate a brand new contract every single time with new terms, then yeah, arguably you're still under contract. But John, that's so rare. Yeah. Most of the time, the contract simply renews. You sign a new piece of paper, same thing. You continue working. No one even thinks about it. It kind of almost rolls over. Now, in those situations, once you have 3 or more, the law says, who cares? Those pieces of paper are meaningless. You're a regular employee. You're an indefinite employee. And if you want to be let go, if the company wants to let you go, full severance has to be paid. You can also go to pocketemploymentlawyer.ca to find out how much that would be.
Talking about fixed-term contracts and being on one, what happens if the company decides to make some changes while you're still under contract and doing the job?
So we know the general rule that a company does not have a right to make significant changes to the terms of employment. A company doesn't have a right to change your job, to demote you, to change your pay, to relocate you. Well, the same applies when you're on a fixed-term contract. If you signed a contract for a year for position X with salary Y, those are the terms of your employment. The company can't change that. If they do, you can still pursue it as a constructive dismissal and get the severance that you're owed, which, by the way, is the difference, the balance in the contract. Nice. So if after 3 months into your 1-year contract, they say from now on, we're changing your job. It's not going to be what we hired you. It's going to be a different job. Well, now you may be able to say, that's a constructive dismissal. I'm out of here, and you have to pay me for the last 9 months on the contract because you're the one employer that breached it.
Again, employmentlawyer.ca, the place to go, the website to find past shows of the TV show and both the radio show as well. Call number 2 from our radio show is coming up right now.
I had a coworker that was let go after 13 years, got 39 weeks severance, and the company made him sign a letter saying that he would take no further action against the company for collecting any extra money. Should he have signed that, or what would happen if you don't sign it?
Good questions.
So, this is a very common situation. It's the reason we started doing our radio and TV shows all these years ago, people accepting inadequate severance. This is a classic situation of that. Been there for 13 years. Company offers them 39 weeks. Let's call it 9 months pay or so, and says you better sign this or else. He signs it not knowing any better. And guess what? It's not adequate. It's not even close. He's owed more than that. So rather than me tell you how much he is actually owed, let's go to pocketemploymentlawyer.ca and let's plug that in. So we'll assume his position and his age. We don't necessarily know that. We do know he's been there for 13 years and he was offered 39 weeks pay. Pocketemploymentlawyer.ca, you can see that on the screen, assesses him as being owed around 16 months pay. 16 months pay. So in that example, that's another 7 months pay. Wow. 7 months. Unfortunately, the bad news is he accepted that severance package. He's owed another 7 months pay. That could be tens of thousands of dollars. But because he's accepted it, he can't do anything. He can't go back. He can't change his mind. That's why it's so important not to go to pocketemploymentlawyer.ca after you've signed, but before. Once you've signed that offer, if you realize you're owed more, there's nothing you can do about it. So first thing you go to, you're walked out of the office, you have those severance papers, you probably call your significant other, tell them, unfortunately, I lost my job. The second thing you do, you go to pocketemploymentlawyer.ca.
When write-ups don't justify termination for cause, that is coming up after a short break. We'll get to it, 1-855-821-5900 and online to employmentlawyer.ca. It's the Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Employment Law Show, welcome back. John Scholes, Lior Samfiru with the phone calls. We get those from the radio show. You want to check it out, employmentlawyer.ca. That is the resource to find past shows for the last, I think we're running 8 years. We're doing a long time. Pretty soon it'll be a decade. You can tell by all the gray hair, or lack of hair in that case. Look, phone call number 3, right, for this show is coming up right now.
Yeah, I was let go about a week and a half ago from my job. I was there for about 4 years or so. I had a couple run-ins with absences that I was written up for due to things. I had a hernia surgery and I was off on modified duties. A week and a half ago, I sent a defect out to the customer that the employer said required a write-up. Now, this write-up, they said, had pushed me to the final stages of a progressive discipline structure. Does that entitle severance, or because of the absences, the random write-up is, in fact, with cause?
So it is right that an employer that wants to fire someone for cause has to build up its case. Yeah. It can't just say, well, you did something wrong, we're letting you go for cause. That's illegal. That's a wrongful dismissal. What an employer should do is build up its case, provide warnings, put that in writing, make sure the employee knows what's expected of them, and make sure the employee knows that if they continue along a certain path, they're going to be let go for cause. So that's fine. Well, the question is, did this employer do it right here? Well, here's the thing. He tells us that he was first written up because of surgery-related absences. He had hernia surgeries, he was written up. Well, that's nonsense. Yeah. He's being written up because he is sick and he has to take time off work because he had surgery? What does that mean? Yeah. So we're going to warn you, don't be sick again or else. I mean, that's absurd.
Totally.
He can't correct behavior when he's done nothing wrong. So right off the bat, it seems to me that those types of warnings are completely illegitimate. And I've seen this before. There's a certain auto manufacturer that should remain nameless, who is very well known for warning people for being absent because they're sick. Nonsense, illegal. But put that aside. If it's illegitimate, the company can't really rely on it. Now, he also says that he sent a defective product to a client. Yeah, he should be warned for that. But it's probably not enough to justify a termination for cause. It's not enough to show that the company warned you. The behavior still has to be serious, and the company has to have reason to believe that there's no point warning you again, you're not going to get it. So let's go to pocketemploymentlawyer.ca and let's find out if there's really cause to let this person go. So we see he's been there for 4 years. He's supposedly being let go for poor performance. Did he do what the company did? Yeah, I guess he did partially. And was he disciplined? Yes. Despite that, you can see at the bottom of pocketemploymentlawyer.ca that even though he has been disciplined for the past 2 years, the allegations don't appear to be serious, and it's probably not cause for termination. So that's how easy it is to go to pocketemploymentlawyer.ca to find out about your situation, to find out what you're owed. And I hate the idea of being disciplined because you're sick.
Yes.
I hate the idea.
It does not help you get better.
It doesn't help you get better. And the whole point of discipline is to correct behavior, right. to identify behavior that's unacceptable and say, don't do that again. So if I have a hernia surgery and so I have to take time off work, what is the behavior you're trying to correct? Don't have another hernia surgery? Sorry, I won't. It's silly, it's inappropriate, and in this case, it's not cause.
We are done for the day. Thank you for joining us. You want to reach out now, employmentlawyer.ca or help@employmentlawyer.ca through email. 1-855-821-5900 is always the number. And remember, always first, go to pocketemploymentlawyer.ca. Enjoy the rest of your time. Appreciate you joining the show. We'll catch you next time in the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.